Number 22, Singh versus City of New York.
Good afternoon, Your Honors. My name is Mark Rifkin. On behalf of the appellants, may I reserve 3 minutes for rebuttal?
You have 3 minutes.
There are two issues in this case. One concerns the dismissal of a breach of contract claim. The other concerns the dismissal of a GBL 349 claim. With the court's permission, I'd like to address the breach of contract claim first. The principal issue on this appeal from the dismissal of the breach of contract is whether the bid form that the city provided to auction off 400 yellow taxi medallions in three public auctions permitted the TLC to disregard long-standing, well-established rules in the code, the New York City Administrative Code, that restricted the ownership of black cars, and in doing so allowed tens of thousands of non-conforming black cars, principally owned by Uber and Lyft, to flood the city streets and compete directly with the yellow taxi medallions they had just sold in those three public auctions. The effect of the conduct of the TLC after the auctions was to substantially erode the yellow cab's revenue and therefore destroy the benefit of the bargain and the value of the bargain that they had just made with the purchasers of those yellow cabs.
Was that the bargain, though? Weren't they just saying, we're going to give you these medallions and you'll have them free of any other encumbrances?
Of course, they were saying that they were going to sell them the medallions, which they did, and they certainly warranted clear title. But the duty of good faith and fair dealing required that the city and the TLC allow the purchasers of those medallions at the upset prices that the city had set for the auctions to enjoy the fruit of that deal. And it is that restraint on the ability of the city and the TLC to do what they did in derogation of the TLC's regulatory authority.
So would your breach of contract action be the same for somebody who bought a medallion 20 years ago?
In all respect, probably not.
Why?
I think that, and this is because the question that the covenant of good faith and fair dealing requires to be answered is whether one party has destroyed the value of the bargain for the other party. And there is a legitimate factual question whether the passage of 20 years would have enabled the purchaser of a yellow cab medallion 20 years ago to have enjoyed the benefit of the bargain, such that if the city had changed the administrative code and permitted these Uber and Lyft vehicles to enter the market without complying with the ownership requirements, if that had then been done, I think it would be a factual defense that the purchaser of the medallions had the opportunity to enjoy the benefit of the bargain. But that would be a factual question and wouldn't be appropriate to dismiss in any event.
So your answer sounds more like a regulatory takings claim than a breach of contract claim.
It is not. It is not. I think it's close, but it is not. Here, the principle is simply this. When the city agrees to sell an asset, any asset, doesn't matter. Yellow medallions happen to be the asset of choice here. When the city agrees to sell an asset, it has the same obligation, the same contractual obligation that every other contracting party in the state of New York has had for a century. Let the other side enjoy the benefit of the bargain.
Counsel, I want to pick up on that point, and I think it follows on what Judge Wilson is asking you. One thing I struggle with in this case is, as I read your count 3 of your complaint, which is your good faith allegation, it goes to, as you were saying, their enforcement of the licensing for black car bases, right? That's what you allege in this count. That's what the city isn't doing.
Well, we respectfully, Your Honor, what we say is that the TLC disregarded.
Right.
That effectively it abandoned its obligation to regulate the industry.
So it's a lack of enforcement of these rules, right? And it's a municipal entity that is looking at a transit system and trying to balance certain things. And I think I am trying to figure out, binding the city for 20 years, should we have horses, if they were, because the cars came, this was technology. And the city, in a way, is responding to that. One, so you have this kind of idea, which I see in Windstar at the Supreme Court, where if you're going to do that to a government entity, it better be pretty clear that they've agreed not to change their regulatory scheme. And I think counter to Windstar, here we have something where that notice arguably lets you know that they reserve the right to change their regulations and their enforcement practices.
There was nothing in the agreement between the city and the buyers
Well,
that
there's
allowed...
this notice, which I know you claim just only goes to clear title, but seems to say, you know, as to the present or future application of the provisions of the rules of the City and Tax and Limousine Commission or applicable law, other than a warranty of clear title. So it seems, at a minimum, that's not under this WinStar idea approach, an unmitigated commitment to do a certain thing with respect to regulations and enforcement.
We don't say that at all, and we don't believe that the court needs to conclude that in order to reverse the appellate division's decision. The fact is that the city hadn't changed the administrative code when it sold these yellow medallions at auction, and it hadn't changed the administrative code when when the TLC allowed these
Why
non-conforming
couldn't they do it in the
admittedly...
future?
I'm sorry, Your Honor?
But you want to bind them from, one, changing the code, I guess, but also from enforcing it in a different way.
No, it's not a question of enforcement. The TLC lacked the authority under the administrative code to allow non-conforming, admittedly non-conforming black cars to flood the market. There's no question that the TLC was not authorized to do what it did. The city doesn't defend on that basis. If the city had changed the administrative code, I agree, we would be looking at a different fact
Is the
pattern.
logic any different with respect to a lack of enforcement? I mean, let's assume that there was no agreement to change the code, but you're saying that there's some implied warranty that compels the city to enforce its regulations, and we say in so many other contexts that that's a strictly governmental function, and you could specify it explicitly in the contract without the disclaimer language, which is problematic, or you could create a special duty that required the city to enforce its regulation in some way. But neither of those really seem to be apparent.
And none of those things is required here because the facts in the case are far simpler than that. Had the city wanted to change the administrative code, it would have had to go through the appropriate legislative procedures and deal with the appropriate political consequence of its desire to do that. No one is suggesting that the city did not have the right to do that, and no one is asking the court, certainly we are not asking the court, to impose on the city any obligation to keep the administrative code in place. That simply isn't part of our case. But without having that, and without having the protection of a change in the law, the buyers of these medallions, the property owners who bought these medallions from the city, had a right to expect that the city would act in good faith and deal fairly with them. And if the city intended to change the code, as they did years later, the city had an absolute and unqualified right to do that. But in the meantime, these buyers had a right to rely on the duty of good faith and fair dealing in the absence of a change. We are not asking the court to impose any restraint, any restriction whatsoever on the city's ability to change the administrative code. We're simply saying play by the rules. It reminds me a little bit of the
But you're
argument
saying
we heard just a moment ago.
Chief Judge Canatero's point, you're saying enforce the rules. And that's a fair argument. It's just that it's a municipality, and again, in WinStar, it says it was found, and, you know, not binding, but this is how they approached it. The government had plainly made promises to regulate in a certain fashion. Here, you don't have a promise to regulate in a certain fashion in this contract.
Agreed.
In fact, you have that language in that disclaimer saying, you know, we can change the rules.
Well, nothing in the bid form said that the TLC had the right to ignore the regulations. Nothing in the bid form said that the TLC had the right to license non-complying black cars. Nothing in the bid form said that the TLC could abandon its regulatory authority. Nothing in the course of dealing between the parties suggested that the TLC was going to do that. It was unprecedented. And the city's argument that it had done so is premised respectfully on some misstatements about Uber's presence in the marketplace before these auctions took place. Uber wasn't even identified, mentioned at all. E-hailing wasn't even a subject that was described in the 2014 taxi fact book.
You started by saying that the rule you're advocating would apply to any sort of asset sale by the city. And so that makes me worry a little bit. You know, for example, there's a big piece of municipal property, the city sells it to a buyer, the city had been actively policing the area, and then decides to divert its police resources somewhere else afterwards, and the buyer then makes the same kind of argument you're making, that now crime is running rampant through the development they're planning to build, and this is a problem, and this breaches the good faith and fair dealing covenant in the contract. Because they've allocated their enforcement resources differently.
And if the city had the discretion to do that.
Well, that's the question here,
And that's-
right?
And of course, that is the question. And to us, the difference is that here, the city told the TLC the conditions under which it could license black cars. And those ownership requirements forever had restrained the marketplace. And that's why the number of black cars, prior to these 3 auctions, the number of black cars had been relatively consistent. And it was only when the TLC stopped following the city's policy and did not comply and did not enforce the regulations that it was obligated to enforce, it was only then that the number of black cars exploded and destroyed the value of the medallions they had just sold for almost a $500 million. That's the difference. We see this not as an exercise of the city's legislative prerogative or administrative discretion. We see this as a failure of the city to abide by its own rules and regulations, to play fairly under the rules that said a black car has to qualify this way. In a sense, it's non-discretionary. The black car must meet the ownership and franchise requirements that are set forth in the city administrative code. There's no dispute they did not do so here. And we submit that in the absence of any kind of authority for the TLC to allow these non-complying, non-conforming black cars to flood the market, it was a breach of the duty of good faith and fair dealing for
So
them
the
to
city,
do
I think,
so.
I just read in the papers, I'm not sure if this is correct, announced that the current administration has decided not to prosecute unlicensed vendors. So do people who paid for vending licenses now have the same type of claim that you're advancing?
No, I suspect that the decision whether to prosecute falls within the discretion of the policing power of the city.
That may destroy the market for the licenses.
It may or it may not, but again, it may fall within the policing power, the discretion of the policing power of the city. But the TLC had no discretion to ignore the administrative code, respectfully.
Thank you.
Would the court care to hear any argument on the GBL 349 claim?
No, thank you.
Okay, thank you.
Good afternoon, Your Honors. Jesse Townsend for the respondents. The court should affirm. On the implied covenant claim, plaintiff's claim as pled is precluded by the clear terms of the bid form and subsequent documents that the plaintiff's principal freely executed and agreed to. And the theory focused on appeal, which is this idea of the commission changing its approach in some way, is not pled.
What did plaintiff buy? What reasonably, objectively did plaintiff believe that plaintiff had purchased?
Plaintiff was buying a medallion that allowed him to run taxis subject to the commission's rules, which is stated in all the agreements that he freely executed, as those rules were applied, to answer street hails, and that was fulfilled. Uber's, the classification of using Uber to arrange a pre-arrangement as opposed to a street hail was clearly stated by the TLC 2 years before the auction, Your Honors.
But you understand why they feel duped, no? I mean, you think they walked into this with their eyes open, or it was their fault, or something like that? You don't think that if they had known what they know now, they would have struck the same deal?
I think they're disappointed, and that's fair, Judge Wilson, but certainly Uber entering the New York City market and markets globally had a huge impact. That's true. That wasn't covered by the implied covenant.
What would be covered by the implied covenant here? What does the contract pertain to, and where does the implied covenant come in, hypothetically?
Sure. At a hypothetical level, for example, Your Honors, I believe the contract requires someone who wants to sell a taxi cab medallion to submit that, or finance it, to submit that to approval by the commission. If the commission just, for example, refused to look at that application or was unreasonable in rejecting it, perhaps that's a implied covenant type claim.
What if you sold 10,000 medallions the next year?
So, again, Your Honors, given that the purchase was subject to the commission's laws and rules, I think that's not an implied covenant claim. The fruit of the bargain was to receive these medallions to run the street hails, to answer street hails.
So the city could have authorized the creation of an additional 10,000 medallions 6 months later and auction those?
In that case, perhaps there's a different claim because the commission usually sold medallions in response to state legislation, as this court heard in 2013. The medallions that this plaintiff was purchasing were part of up to 2,000 additional medallions that were to come online, as well as up to potentially 18,000 what's called green taxis that were to be sold because of the HAIL Act that was passed in 2011 and 2012. So even in that scenario, Your Honors, the purchaser was buying knowing that there were a great deal more competitors entering the market, or potentially entering the market.
Yeah, but nowhere near what ended up happening. So what about that argument that you're intentionally undermining the value of these medallions?
Sure, Your Honor. So we certainly disagree that we intentionally undermine the value of the medallions, and the complaint nowhere alleges that there was a change, a deliberate change in the commission's approach. It's a motion to dismiss, so I'm bound by the allegation that these black car bases did not qualify. That's at pages 67 and 68. But also at 67 and 68 is the allegation that these black car bases affiliated with Uber, several of them had been approved up to a year before the auction. And nowhere in the complaint, on the other hand, is there an allegation that the facts, that the commission knew that fact and then changed its approach in some way, or that it varied its approach as between Uber-affiliated black car bases and all the other black car
So
bases.
is the difference that you're arguing is that plaintiff paid for hailing rights, and these other cars aren't allowed to do the same thing? So he got what he bargained for, so they got what they bargained for?
He got the medallions he paid for, yes, Your Honor. The taxis have a monopoly on street hails. And in 2011, the commission had clearly stated that using Uber was a pre-arrangement, not a street hail. And that, again, predates that auction. It did not change.
So allowing the pre-arrangement, your argument is, does not undermine what the plaintiffs bargained for?
It does not, Your Honor, and again, it predates the contract. So when considering the implied covenant, we think about what would a reasonable purchaser understand to be an unstated promise of the agreement. Given that the commission had already stated that the use of Uber was a pre-arrangement and not a street hail, a reasonable purchaser couldn't think that when buying a taxi cab medallion, he was buying the right to have Uber not be treated as a pre-arrangement.
But you didn't take that into consideration when you set the price for the medallion.
I think the taxi cab medallion, the commission took the market of the taxi cab market as it existed and set the price accordingly.
Is there any claim under the implied warranty for the failure to enforce the requirements as they existed for the black car permits?
No, Your Honor, precisely because of the express language of the bid form, example of which is at page 135, that clearly says present or future application of rules or law. This is a reservation of the commission's authority to enforce the rules and law as it understands it. That's exactly what that language means.
Their point is you don't have the authority to disregard the rules.
That was as a municipal entity, a regulatory entity, we have the authority to apply our rules as we understand them. We had that authority before the agreement. That language in the bid form reserves.
So you understood these black car bases to be legitimately licensed under the rules as they existed at the time?
Right, Your Honor. And I just want to respond to something the opposing counsel said in terms of no dispute. There is a dispute. Outside of again, this is a motion to dismiss, so I'm bound by the allegations in the complaint. Outside the motion to dismiss, absolutely we dispute that. Absolutely we dispute that they did not submit documentation or that we had any reason to think they did not comply. But even within the confines of the motion to dismiss record, Your Honor, we had a very clear language in the bid form that specifically state that We were making no promises concerning the present or future application of our rules or applicable law. So we were reserving the rights we already had to regulate as we understood it. Using the implied covenant to allow the plaintiff to get out of that language, it just would really undermine these concepts of contractual certainty and predictability that underlie the approach to contractual interpretation in the state. Your Honor, if I could just turn briefly to the GBL 349 claim. The question here is whether the word tort in the statute 50E means only statutory, excludes all statutory causes of action from its ambit. There's really no support for that. The plaintiffs rely on Guidon 2. The point in Guidon 2, though, is that in this court, the court said that GBL 349 claims are similar to and akin to common law fraud claims. In Guidon, this court had to fit this into a binary. Fraud, 213.8, statutory, 214.2. There's no binary in 50E. It just uses the word tort. So as long as it's akin to the common law tort of fraud, 349 logically fits within.
Are all 349 claims akin to tort? Could there be some, in the Venn diagram, could there be some class of 349 claims that don't look like torts?
I don't think with regard to 349, Your Honor, given that 349 is meant to be a consumer fraud protection statute, and again, it's similar to and draws from the common law of tort, I think it logically would flow that 349
What about some
claims.
just highly misleading representations about the quality of a service or a product? It doesn't sound very tortious to me, but it could conceivably be a 349 claim, couldn't it?
Well, again, it would be pretty similar potentially to common law fraud, which obviously no one disputes is a tort, Your Honor. So I think that it would be hard to say that 349 claims would not be torts, and certainly here, where plaintiffs based their allegations of 349 on very similar allegations that overlap with their now abandoned fraud and negligent misrepresentation cases, this wouldn't be the case to reach it.
I have to say,
I'm sorry.
I wonder if, this looks to me really like regulatory activity at bottom. I think, you're trying to regulate how people are moving around Manhattan, how many taxi cabs are going to be, black cabs are going to be, subways, all various different methods of transportation. And to apply a GBL 349 to a regulatory decision like that seems weird to me.
That's a fair point, Your Honor, and Supreme Court held as an alternative ground for dismissing the 349 claim that 349 did not apply to a municipality, including engaging in actions such as this. That is certainly an alternate grounds for affirmance of the 349.
Is that settled law, or is that a novel holding here?
The Supreme Court was drawing on prior case law that involved state agencies, so to the extent it's novel, it was just the extension of the same concept from state agencies to the municipalities. With regard to the idea that this is discretionary activity, I would note, Your Honors, the Appellate Division, Second Department, rejected the claim that under an Article 78, someone could force the city to apply these black car base rules in a certain way. I believe that was the Progressive Credit Union case. Because this is a discretionary action. It's a policymaking action, and so mandamus didn't apply. Thank you, Your Honors.
counsel.
Your Honors, I heard counsel for the city say that the upset price, the minimum bid price, was set in the auctions on the basis of market conditions as they existed at the time of the auctions. Those market conditions never changed. They were that black cars had to be owned by either a franchise or a cooperative. These black cars were neither. At least that's what's alleged in the complaint. And we'll be mindful that this was a motion to dismiss that was effectively granted by the Appellate Division. Those conditions never changed. However, once these 360 medallions were sold to these buyers, the TLC, without changing those market conditions, radically changed the landscape by letting now non-conforming, for the first time ever, let non-conforming cars into the market to compete directly with the yellow cabs that they just sold those medallions for. And we think that's why the duty of good faith and fair dealing applies so squarely here.
What about the argument that the cabs had the hailing rights, and the Uber cars are prearranged.
Before these auctions took place, the only Uber base that had ever been licensed, and the only mention of anything about it, was a license that was granted in 2011 to a luxury limousine service that was owned by a base called Uber. Am I right about that? Not even Uber, but Uber. It was in fact what Uber became, but that was it. It was licensed as a luxury limousine service, not even as a black car. It was licensed as a luxury limousine service. The 2014 fact book that the city published didn't even mention Uber, didn't even mention Lyft, didn't even mention e-hailing, none of this. None of this was even considered by anyone to be market conditions as they existed at the time the city set the upset price for the medallions that were sold, and at the time the buyers bought the medallions. This was a radical change. It was not within the history of the parties. It was not within the regulatory prerogative of the TLC to do it. And if we're going to lead to the conclusion that it was, it certainly requires that the issue be explored factually and developed, not appropriate for a motion to dismiss. If I may, very briefly, I'd like to turn quickly to 349. The city's position on GBL 349 that it doesn't apply to state agencies was not briefed. It is a new issue. We understand that if the court concludes this, that it's perfectly an acceptable basis to affirm on another ground. But if the court is going to address the question of whether GBL 349 should or should not be heard, should or should not apply to a municipal authority, it ought to do that on the basis of a fully developed briefing record so that we have the opportunity to explain our position on it. But with respect to the question of whether 50E applies, the statute itself requires that the claim be based in tort. And we're talking about all sorts of metaphysical distinctions here, and the tort theory of GBL 349 in the city's view seems to be shifting shapes from one statute to another statute. Our position on it is very clear. This court has already said that GBL 349 is different than fraud claims. It's not a fraud claim. For example, you don't need to prove reliance to prove a GBL 349 claim. That's an essential element of a fraud claim. You don't need to prove intent to prove a GBL 349 claim. That's certainly an element of a fraud claim. All of these things mean that a GBL 349 claim is not a claim founded in tort. The city is asking that the court rewrite GML 50E and change those words from a case founded in tort to a case similar to tort. And of course, I don't need to reemphasize the fact that the city has taken contrary positions on whether it's a tort for one purpose and not a tort for another purpose. We can't have that. That sort of uncertainty is not the sort of thing that we ought to be deciding these statutes of timeliness under.
Thank you.
Thank you very much.